Alrighty, good afternoon, folks. It's 12:05. We're coming out of recess for the purpose of hearing a couple of land use items. We've got three today. One is a brand new rezone. The other two are continuances of previous hearings. We're going to take things a little differently on the second one, the Crick World application heard by the Planning Commission, and we went through our public comment period at the last meeting and it closed public comment and asked staff to look into several issues that had come up and then give us some feedback on those before we moved to final decision. It's apparent there were some folks that did not realize that public comment had been closed, so when we get to that, we're going to recess and depart, and Matthew, the planner, will kind of do some Q&A with you if there's issues that didn't come up initially or some new issues that he feels need to be brought to us before final decision. When we come back, we'll pick those up. But we are in a public hearing process, and there's things that we're bound to follow in order to make sure that at the end of the day, if a decision is made, that it does stand scrutiny if it is reviewed by the court. So appreciate that. As in all of our hearings follow the same general process. Staff will provide a presentation of the application and give us their recommendations. The recommendation that came out of Planning Commission, if it was an item that went through Planning Commission, we'll invite the applicant up to provide additional information if they have any. We may have questions for staff or applicant at that time. Then we open public comment, we take public comment, we invite the applicant back up to respond, may have questions for applicant or staff at that time, and then we move on to a decision which can be approval, disapproval, approval with conditions, or a further continuance if we feel there's more information that's required based on the comment we've heard, which is kind of where we were at with the Cricket World one. As I said, today we're hearing two different types of application. The first is a rezone, changing uses by right and potential special uses. The second was a special use by review of ag zone property. The third is a request for rezone of a lot within a current subdivision. But again, the hearing process is generally the same for each. So with that, Matthew, I'd turn it over to you after we open public hearing. So I would take a motion to open public hearing on the Snyder rezone.
I'll make a motion we open this Snyder rezone case RZ-22-0034.
Second.
We have a motion and a second to open public hearing for the Snyder rezone. All in favor, please say aye.
Aye.
Aye. Motion carries. We're in public hearing. Matthew.
Good afternoon, commissioners and guests. My name is Matthew Carney with Elbert County Community and Development Services. I'll be presenting the Snyder rezone case RZ-22-0034. Again, this is a rezoning request from Agriculture 2 to Agriculture Residential at a location of 31141 Private Road 23 in Elizabeth. Generally, the location of this property within the county is just south of the town of Elizabeth, in proximity to County Road 1721. The landowner and applicant is Brian Snyder. There is a concurrent review of a plat application, minor in nature, to split the property that is being rezoned into two lots. A pre-application occurred for this proposal on April 7th of this year. A community meeting was held in Elizabeth on May 18th of this year, and a formal application was submitted on June 1st of this year. This application was heard by the Planning Commission on August 2nd. There was a recommendation of approval for this rezoning, and there were two public comments that were given for this application in particular, but one was mostly in support and the other one was really to get clarification on what I guess, the extent of the proposal. And the notification was completed in accordance with the zoning and subdivision regulations. In looking at the zoning map here, we have the only A2 zone property in the area, and that's primarily because this is Lot 2 of the Watts Minor subdivision, which was 40 acres, split into 2 lots, one of which is AR. Lot 1 directly to the west, and this subject property is about 29 acres located on the east. Generally, there's a handful of other small AR and RA subdivisions along County Road 1721 in this area, primarily in Ricci, Fine, Sarek, and Grith-Glen, but there are also other subdivisions such as Arrowhead, but those are accessed through State Highway 86 and not from 1721. And looking at the property in general, this is an undeveloped lot in a large parcel type area. However, there have been some of these minor developments that I alluded to that have gotten the density a little bit higher in this area. There is some sparse vegetation on the property, but no notable floodplain in the area that would affect this property. So looking at the site specifics, this is the future subdivision layout of the property that is to be rezoned here. One of the requirements that I'll be touching on in the coming slides is for private road 23, which is located off of the property but serves as the access point for this future subdivision. That was a request of the Elizabeth Fire Protection District to have that portion or segment of road improved to Type 1 road and bridge gravel standards. You can generally see the discrepancy between private road 23 as it reaches the property, and the red's a little bit in the way, but there's not as much thickness, I guess, even in an aerial map to see that that road is a lot narrower than it should be for the potential impact in the area. So that was a request made by the Elizabeth Fire Protection District to have that portion of road improved, at least through the balance of the property, for the additional impact generated by potentially an additional home on this property. So in looking at some of the referral responses that we had, I just touched on the Fire Protection District Elizabeth Fire's response to upgrade private road 23. That also includes the fire flow requirement that we see with a number of applications within the Elizabeth District. They have options that an applicant can select, whether that be sprinklering a building, putting a cistern on the property, or paying a per lot cash and lieu fee. The applicant in this situation has elected to pay the per lot cash and lieu fee for the subdivision. Those, again, will be conditioned for the plat approval because it's really the impact of the subdivision which necessitates the per lot impact fee and then the improvement of the road there. The response that we received from the Division of Water Resources, a lot of this water was sorted out with the Watts subdivision. However, this particular amendment to that subdivision will be for approximately 3/4 of an acre foot per year per lot. There are 2 well permits already that have been applied for this property as well, and they've slot in very well with the determination that was completed before. What you might have seen in some of the referral responses is that there was not a very clear delineation between both of the lots, but additional information was provided for the division to give an adequacy letter and that water supply will not cause injury to surrounding property owners. There's also another referral response from the assessor's office as well, but they more or less were looking for a form to be filled out for the agricultural status and in general the questionnaire that they have for determining that ag status. In looking at the review criteria for a rezoning request, we have 6 criteria that are applicable. The first of which is the relation of the rezoning to the comprehensive plan. Is it conforming? Is it consistent with the comprehensive plan? And staff has found that there's not a lot of goals and policies that really speak to this type of proposal where we have a small density change, potentially adding an additional roof or 2. Really what we have found is that the vision of the comprehensive plan is to respect private property rights while also encouraging residential growth among other forms of growth. In general, that staff believes that this request falls in line with that general vision statement within the comprehensive plan. Criteria B, whether the proposed rezoning is compatible with surrounding land uses. In general, staff has found that this area southeast of Elizabeth has seen some sporadic development of 10 to 20 acre densities over time, and in general that this property is approximately 3 miles to the town and some of those adjacent Elizabeth subdivisions like Elizabeth Park and the Pines as well. There are additional subdivisions such as Arrowhead and Pinecrest Estates that have shown that an increase in density in this area can be appropriate as well. However, most of these proposals are in closer proximity to county roads than this property, though. Criteria C, whether the proposed rezoning would have an adverse impact on public services, and in general to criteria D as well, whether the proposed rezoning would have an adverse impact on the environment. We have a number of referral agencies from the Kiowa Conservation District to Elbert County Road and Bridge to Public Health as well that analyze the application for these potential impacts, and from the referrals that we have completed, we do not believe that there will be a significant impact to either public services or the environment. Criteria E, whether the proposed rezoning would create unreasonable traffic congestion or burden the existing road system without improvements. This project has had a direct comment that road improvements need to be made for this potential density change, and that's something that the applicant was very keen to jump on and offer to do, to have the subdivision put in and add density to this area. So the roadway improvements were identified pretty early on in the process, and it has carried its way through. That the understanding is that for the rezoning and the subdivision to go through, that the traffic congestion or the burden to the road system in the area will be addressed by that improvement of Private Road 23. And criteria F, whether the proposed rezoning will not otherwise be detrimental to health, safety, or welfare of the present or future inhabitants of Elbert County. Staff has found that there will not be an adverse impact to health, safety, or welfare given the review that was completed, the responses that were collected from referral agencies, and the analysis completed with the zoning and subdivision regulations for this proposal. With that in mind, the Planning Commission recommends the Board of County Commissioners approve the requested Snyder rezone, case RZ220034, based on the following findings: that the proposal is in general conformance with the Elbert County Comprehensive Plan, that the proposal meets the criteria for approval in the Elbert County zoning regulations, that the proposal is compatible with existing and allowable land uses in the surrounding area, and that the proposal will not result in significant impact to the health, safety, or welfare of landowners in the surrounding area. This approval is subject to the following conditions: that the applicant will be required to remove the public hearing sign within 7 days of a decision, that the rezoning will not become effective until all fees are paid, conditions of approval are met, and the rezone exhibit is recorded, and generally that this recordation occurs within 180 days of the Board of County Commissioners' approval. And that will conclude my presentation.
Thank you, Matthew. Do you have any questions for staff at this time? Okay. At this point, I invite the applicant to come forward. If you could give your name and address for the record, and if you have anything else you'd like to add to what staff presented.
Sorry, I thought Matthew would have found an extension to the microphone here from last time. I'm just kidding. No, my name is Brian Snyder, 8816 Lance Leaf Street in Parker, Colorado. I think Matthew did a good job outlining everything. Before we started the subdivision process, we tried to meet every neighbor within that quarter-mile, vicinity to kind of be fully transparent with what we wanted to do. I think that the big sticking point with most of the neighbors out there was that Private Road 23 and all of that, which is why, as Matthew alluded to, that's going to be our top priority. It's going to be the very first thing that we do, assuming everything goes through. We're going to make sure that road gets taken care of. And really everybody out there, all those neighbors, will directly benefit from having that private road completely fixed up. So that's going to be wasn't a planned expense to do that road. It's going to be expensive, but like I said, we're happy to do it to make the neighbors happy out there, and it'll be good for everybody. So that's the only thing that I have. So.
Okay, thank you. Any questions for the applicant?
No, I mean, do we need to make it a conditional approval that 23 is going to be done? That, you know, we've talked about it, you know, that the fire department's going to require it.
Rick, Commissioner Pettit, I have that as a condition for the minor plat approval.
Okay.
So we felt it more effective to have those Elizabeth Fire conditions of approval put in with the plat, because really the addition of that additional lot, potential roof there, that's where we would look to have that improvement made for.
Okay, that makes sense to me.
That does. Okay. All right. Do we have any public input on this project? Amanda, I don't believe we received anything via email or requests for phone calls.
No, we did not.
Okay, so with that, I would close public comment. Mr. Snyder, I do have one more question for you. So, and that is simply the three conditions that were up there of approval. Do you accept those conditions?
Yes.
Okay, thank you. So with that, I would accept a motion.
Mr. Chairman, I move that we approve the Snyder rezone RZ 22-0034 with the conditions of approval.
I'll second.
Okay, we have a motion and a second to approve the Snyder rezone RZ 22-0034 with the conditions of approval that were listed. All in favor, please say aye.
Aye.
Aye. Motion carries. I'd accept a motion to close public hearing on this item.
I'll make a motion. We close public hearing on Snyder rezone RZ-22-0034.
Second.
Okay, a motion and a second to close public hearing. All in favor, please say aye.
Aye.
Aye. Okay, that hearing is closed. So, congratulations. All righty. As I said earlier, and I think there were a couple of folks that might have been out of the room, we're going to take a brief recess at this point. There were apparently some folks that had some comments that they wanted to get in regarding the Crick World SUR. We had closed public comment in the last session of this hearing and had a few issues that we had asked staff to look into. So I'm going to, once we depart, I'm going to ask Matthew just to take any additional comment, kind of a Q&A, if there's some new issues that arise that we need to hear about prior to the items that we'd asked staff to look into, then we'll take them at that time. So again, it's a little different than we normally hold it, but do want to make sure that if folks do have issues that we haven't already heard that truly impact on the final decision, that they are presented in a public hearing, and that we aren't unnecessarily advantaging or disadvantaging either the applicant or our citizens. So
you're thinking about 10 minutes?
Let's go with 15, and we'll reconvene at 1:40. Thank you. Friday. It's 1:42. We're coming out of recess. Appreciate the accommodation. So with that, would entertain a motion to reopen the hearing into the Crickwill Sports Fields SUR.
I'll make a motion, we open the hearing on Crickworld Cricket Fields SUR case SU-22-0005.
Second.
Okay, I have a motion and a second to reopen public hearing into SU 22-0005. All in favor, please say aye.
Aye.
Aye. Motion carries. We're back in public hearing. Matthew, appreciate you kind of leaning in on that. If you could, just kind of a summary of what may have been brought to you and if it's different or new from what we had heard during previous public comment, and then
Commissioner Richardson, I reviewed the documentation I've been provided either over email or in writing today, and I found the similar topics that we had discussed from the previous hearing, accounting for most of those letters. There was one comment that I will raise to your attention, and I believe this is from Mr. Gary Downing, although his name's not on here. There's one comment in particular that I believe was raised during the Planning Commission hearing about wildlife and how that's affected on the property as well. And generally what I can speak to that is we have a number of referral agencies, Colorado Parks and Wildlife, Kiowa Conservation, that we refer to for these applications. And more often than not, we'll get very small responses generally for those types of things. I did not receive any comments from either of those two agencies speaking to the potential of this development affecting wildlife in that area. I'd just like to make that known to you that that was a comment that I flagged that was different than any potential access or roadway related concerns that should be made aware to you.
thank you. Any questions for Matthew on that? Okay. And I appreciate that. For the items we had asked you to look into after we closed comment at the last session, could you roll through those for us?
Absolutely. Commissioners and guests, Matthew Carney with Community and Development Services again, just to cover a couple of details that were left hanging from the previous August 10th hearing. There were three main concerns that were raised during that hearing that needed additional investigation by staff. Those three things being the safety of County Road 41 and 102, that intersection, potential limitations regarding easements used to serve the property, as well as concerns over the county-owned portion of County Road 41. And I'll cover those three items now. And to note to the commissioners, I have my slides that I presented from the previous hearing if we need any reference material. So feel free to ask if you need any additional information. So to cover the County Road 41 and 102 intersection, the resounding comment that we've received from Elbert County Road and Bridge that dangerous intersection signs are not posted by Road and Bridge. And in general, the statement that I can provide from CDS, even with the sign code that we have within the zoning regulations, that non-permitted signs that are adjacent to public county roads or within the right-of-way could be subject to removal. And in general, we received a comment from the Sheriff's Office that there was only one recorded crash at this intersection, and that occurred in 2017. Regarding that, staff has identified generally that if the dangerous intersection signs are placed there, those are essentially illegal signs, more or less, and can be subject to removal. If there are dangerous intersection signs at different points in the county, those are erected by a landowner or somebody other than the Elbert County Road and Bridge. Regarding the access easements, we have three in particular that will be used to serve this property as well. I've put in a little bit of language from each of the deeds there. From my understanding, easements that are dedicated by deed do not have limitations unless they are expressly stated in that deed. I could not find anything within these documents that would lead to any form of limitation to use or density or anything of that nature that might have been brought up in the previous hearing, that these easements are to be used for access, and it's not stipulated as to who should be accessing those. It's essentially ingress and egress for people that live off of that easement. And regarding County Road 41 as well, this one was not as big of a concern following the hearing, but I'm reiterating a number of comments that I brought before, that Road and Bridge is not requiring this portion to be improved at this time. And really, they're using their traffic count that they anticipate taking upon approval of this project to dictate what improvements need to be made to this road. One comment I'll make is that it is not located on the section line as it was probably anticipated. It could be moved if needed, but that property owner affected would have to provide a survey to Road and Bridge to be able to initiate the process to move that road back to the section line. And to reiterate again, that the applicant is to build a private road from the end of County Road 41 to the project site. I guess from this point, are there any questions that you have or any information that you would like me to touch back on?
It's my understanding on easements where they're deeded and stuff that any easement, if it doesn't say exclusive, is a non-exclusive easement, the way I understand it. So if there's no exclusions to it, then I don't think they're limited, but that's my understanding. I don't know if that's correct or not. Any idea on that part?
I think generally that's true. And as far as the comments that I believe were brought up at the last meeting or hearing on this being a prescriptive easement, I don't see these being prescriptive easements at all. I see these being dedicated easements. And even were these prescriptive easements, I don't think the ingress and egress to this particular parcel of property necessarily increases the burden on a surveying estate, which I don't think that's applicable in this case, even though that has been claimed.
Okay, yeah, and I mean, that was I looked at some of the statutes on easements, and that's sort of what I read. As far as the dangerous intersection sign, I think that may have been put up 20 or 30 years ago. I know presently the county does not put up those type of signs.
Grant, do you have anything?
Yeah, I'd like to hear the applicant. I've got a couple questions for him.
Okay. All righty. I don't have any questions for staff at this time, but yeah, Mr. Mendinga, if you could provide your name and address, and then Commissioner Thayer had some questions.
Hey, good afternoon. My name is Raja Mandiga. I'm from Parker, 11931 Ridgeview Lane, 80138.
Yeah, the questions I have are related to the easements, but not really the easements, but the roads that would be constructed on those easements. You understand that you would have to get a permit from the County Public Works Department and build the roads. Even though they're private roads, you'd have to build them to county standards.
Yes, sir. I agree.
Would you accept that as a condition of approval?
Yes, sir.
And also to include that prior to the initiation of cricket activity, you would have to get a approval from our Public Works Department?
Yes, sir.
You'd accept both of those as conditions of approval?
Yes, sir.
Thank you, sir. I didn't have any specific questions for you. And actually, if you could, Matthew, if you could bring up the conditions of approval that had been recommended. So,
All right, to touch on the conditions that are present, there were 6 that were available for the initial hearing on August 10th. Before this meeting, a representative from the Elbert Fire District let staff know that there was a miscommunication over the referral response that was provided by the fire chief however long ago. So we have added an additional condition beyond what you have seen in your staff report that should cover the needs of the Elbert Fire Protection District. So these are the first 3 conditions: that the public hearing sign will be removed within 7 days of a decision, that the special use by review will not become effective until fees are paid, conditions of approval are met, and, pardon me, the special use by review exhibit is recorded, that this recordation occurs within 180 days of board approval. Condition 4, that the applicant shall increase the size of the parking area if directed by the Elbert County zoning compliance official if the current parking area is found to be insufficient for the approved uses, that the applicant shall be responsible for all access improvements that may be required by Elbert County Public Works and/or Road and Bridge following a traffic assessment to be completed after the proposed use begins operation, that the applicant will revise the special use by review exhibit to contain the correct easement reference information, and condition 7, that the applicant will be required to complete all fire improvements requested by the Elbert Fire Protection District prior to issuance of building permit for the proposed structure.
Thank you. Just based on the discussion between Commissioner Thayer and the applicant, I do believe just an 8th to specify that the road will be constructed and approved to approved standard prior to any use of the facility. That should ensure that emergency equipment can get in and out if need be, if there are people on site.
Would you like me to repeat kind of my feeling of what that condition would look like? Yeah. The applicant will build the private roads to county standards, and prior to the initiation of cricket activity, the private roads must be accepted as adequate by Public Works. And if you can correct my English, that would be fine.
Okay. I see the applicant is nodding in agreement. So, sir, if I could...
Yes, sir, I'm in agreement.
Yes. So if you're good with the conditions that were asked of you. Okay. Thank you.
Thank you so much.
All righty. Do we have any other questions for staff or comments? Okay, so with that, I would accept a motion and any other, and we can have any final comments.
Mr. Chairman, I move that we approve Cricket Sports Fields SUR SU 22-0005, and the applicant will accept the conditions of approval.
I'll second.
Okay, we have a motion and a second. Any final discussion? Or? Okay. All righty. Just before I ask for a vote, I wanted to kind of roll through the issues we had heard and the photo that was shown. So I do have some concerns on the intersection of 102 and 41. At the request of one of the citizens, I did go out there last week and drive those roads. In terms of conditions, fortunately or unfortunately, 102 is in very good shape compared to some of our more heavily trafficked gravel roads, but the offset of those intersections is a concern. So as you can see there, that's looking north off of the southern leg of 41, and the hill crests just to the east of it. So somebody turning to the west to drive, if somebody comes flying over the hill at excessive speed, that could certainly result in an accident, kind of less so for turnings in other directions on or off. So though the county no longer uses, or it's been decades before they've emplaced dangerous intersection signs. We do have caution signs, and I think it could be appropriate to have, and we will have Road and Bridge look at that in terms of we have danger vehicle entering, we have cautionary lower speed limits in areas, and that may be appropriate. The limitations on easements, I think, was discussed quite a bit, as well as required improvements for access. In looking through our zoning regulations, this is intended to be a private sports facility, and by our regulations that requires a use by special review. Oddly, if it were open to the public, a public recreation facility on ag land, it's a use by right. Had that been the option that was presented, there would have been technical site planning, but not public hearings held, it's kind of an interesting disconnect in my mind. But the fact that we've had 2 public hearings and kind of fleshed things out, I think there's one large building that's consistent with, it's going to be a tin building like many of the other large ag buildings in the area, a small piece of acreage that's relatively flat land for playing fields and a parking area and a road that's built that will support traffic in and out and emergency response. So I know there were concerns about the compatibility, but again, seems relatively limited use, seasonal use and weekend use in an area where it wouldn't have been unrealistic to have a small rodeo ring or others, maybe more traditional Western sporting events, but certainly not a change in the level of use. So anyway, that's kind of the way I'd looked through these. So if there aren't any other comments, I'd call for a vote.
Should we add a ninth condition of approval that have Public Works look and see if they can put a speed reduction sign there?
I don't think that's not a condition we're placing on an applicant, but I think it's one that would be wise to have staff look at. So, okay. So we've got a motion and a second to approve with the conditions that were presented. All in favor, please say aye.
Aye.
Aye. Anything?
I said aye.
Oh, okay, thank you. So there's three yes votes. The application is approved with the conditions as stated. So.
I'll make a motion. We close Cricket World Cricket Fields SUR case SU-22-0005.
Second.
Okay, we have a motion and a second to close public hearing on SUR 22-005. All in favor, please say aye.
Aye.
Aye. Motion carries. We're out of public hearing on that item. The third item we have today is Liscott Custom Homes Rezone 21-0082. I'd accept a motion to open public hearing on this item.
Mr. Chairman, I move that we open the hearing on Liscott Custom Homes RZ 210082.
I'll second.
I have a motion and a second to open public hearing on this item. All in favor, please say aye.
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 Aye. We're in public hearing. Okay, I will endeavor to speak louder into the microphone. So we have opened public hearing on RZ 21-0082, Liscott Custom Homes. Greg, I'd assume you're the planner on this.
I am.
If you could, this is a continuation. If you could kind of bring us up to speed and on what new material we may have to consider.
You bet. Greg Thompson, CDS Director for Elbert County. Just want to run through quickly some of the basic parameters of this. It's a rezone from RA1 to commercial, so a residential zone to a commercial zone. Generally speaking, this shows where the property is located. It's immediately adjacent to County Road 166, relatively close to the Douglas County line to the west there. The current zoning map is shown. This property and the 3 properties immediately south of that are zoned that RA1. There's some commercial in the area. Immediately to the north, there are a couple different parcels zoned either commercial or business. DB Speed is immediately adjacent across the street to the west as well. Otherwise, generally, there is residential. School is to the northeast as well. This is the subdivision plat showing the property in question. It's a 5.01 acre parcel and the other 3 lots within the same subdivision. Application was submitted in November. Planning Commission heard it on June 7th and recommended approval. The Board of County Commissioners heard that a couple of weeks later and recommended continuance to today. They have 2 different requests that they have applied to the county for a zone change. That is something that's reviewed by the Planning Commission, the Board of County Commissioners public hearing, and then a site development plan, which is a staff review. That particular use that they have proposed is an office and shop for a custom home builder, which is the business that they have. Just some quick details on the property. Already covered those. Site size is 5 acres, RA1 zone, the current zone. I want to give you a point of comparison too with the EDZ, or Economic Development Zone. This is the property here. Properties that are within a residential subdivision can't be included in the EDZ. That's why it's, I imagine that's why it's not shown as being located in there. And other residential areas are also not shown as being in the EDZ. Just some quick background. This property was rezoned to RA1 in May of 2007, and that 4-lot subdivision that we saw the portion of the plat of earlier was also approved by the BOCC. October of last year, there was a proposal for the property immediately south of the subject property to change the zoning to industrial, and that was denied by the Board of County Commissioners, at least in part because that property would have been surrounded on 3 sides with residential zoning. Talked very briefly about the review criteria that's found in Article 3C4 of the Elbert County zoning regulations. How does the proposal comply with the comprehensive plan? Is it compatible with surrounding land uses? How will it impact public services and the environment, as well as traffic and the health, safety, and welfare? The Planning Commission found that the proposal is in general conformance with the comp plan, meets criteria for approval of the zoning regs. The subdivision regulations are not applicable. The proposal is compatible with existing and allowable land uses, and it would not be detrimental to the health, safety, and welfare. And their recommendation was for approval. There were a variety of things that were discussed at the last board meeting. I wanted to kind of touch upon those a little bit and talk about them some. One of the discussions was, well, what if we subdivide this lot and basically call it something else? I think for all intents and purposes, the name that is associated with this lot would be something that would continue on. We typically would reference that Wind Spirit subdivision, it's a re-subdivision of or an amended plat or something. So whether or not that was basically renamed, it wouldn't necessarily remove that particular name from this. That didn't necessarily seem to further the thought or idea about rezoning the property. So just want to give some feedback on that. The one lot PUD idea doesn't work particularly well because we have a component in our code that requires for a PUD to have public water and public sewer. So unless somebody puts together a public facility for just that one lot, that would be something that wouldn't particularly work. Talk about covenants a little bit. The county is not party to covenants. When this subdivision was approved back in 2007, there were not covenants that were put on it at that time. There were some that were added, and if I said it's 2 years ago and somebody told me it's a year and a half, it's somewhere in there. Sometime in the last couple years, there were covenants that were added, and those covenants only were put in place on lots 2, 3, and 4. Lot 1 was not included in that. This application is on Lot 1. The idea of redevelopment came up as well. Well, what if we changed our code and talked about redevelopment? Had some quick thoughts on that, and I don't want to necessarily get into a semantical argument about whether we could use that word or something else, but generally speaking, redevelopment means there's already been development occurring there, that it's not just, well, we decided to change the zoning on the property. It's really that something has occurred and now in the future something else is desired to be there, or it's 30 years ago it made sense, or 50 or 70 or something, and now we're looking to do something different on that. Perhaps our comprehensive plan change. Perhaps the development in the area has changed so much that there's now a shopping center across the street, and having a single family home there makes less sense, or something along those lines that you could look to redevelop something in the future. The fifth one that kind of came up as well is whether or not a special use would be something that would be appropriate here. In taking a look through the table of land uses in our code, there was nothing that was really close to what they're interested in doing on the property. So a special use didn't seem, from staff's perspective, to be a reasonable idea. There is something in there that talks about having a temporary construction office. At our last meeting, or perhaps planning commission, there was discussion about that. They don't want temporary. They'd like to have something that's permanently there at the property. So it's not a 6-month or a year thing. This is something they'd like to have on a permanent basis. So that was kind of the different ideas that were thrown around. There didn't seem to be anything that we could point to say, here's the perfect choice and decision that helps get them to the point of doing what it is they'd like. Some of the testimony that we received at the last Board of County Commission meeting was some of the neighbors, particularly in the subdivision to the east, if I recall, were, I don't want to overstate it, but they seemed favorable to the design that the applicant had put together. And as long as that went in, they were relatively okay with the idea of having commercial there. What the proposal is to have a commercial zone, that they could put that in, but at some point in the future that would be something that potentially could change because there's a broad category of land uses that are possible in that commercial zone. That's about all that I had to provide to you. The applicant is here as well. I'd be happy to answer any questions that you might have.
Any questions for staff? Just one, and I know in passing conversation, but within our current regulation, do you see this is supportable? That what's been requested is something that is supported within our current regulation?
It's an interesting question. Staff had recommended against the zone change. The Planning Commission had recommended in favor of it. I think that part of that staff recommendation came from the direction put forth by the board last October when the property immediately south was recommended for, or was denied, excuse me. That was a different application, different property. I realize that, but it's also some of the kind of basic parameters that were talked about, that it's a residentially zoned subdivision. There was conversation about asking the applicant to, if I say get approval, maybe that's not the right word, but get acceptance, if you will, for the potential zone change from all the people within the subdivision. The applicant can address how their efforts went in that regard. It sounds like that's not something that they have necessarily approval for, or whatever is the right word there. So it's something that having a commercial use immediately adjacent to a relatively busy street like 166, there's some logic to that. There's some commercial in the area, so there's some logic from that standpoint. it's not a black and white, doesn't make any sense, or it totally makes sense.
Okay, I was hoping for yes or no, but I'll take that. Unclear is good enough for decision-making. I guess I'd ask the applicant if you've got anything to add since our last session.
Good afternoon, Commissioners. Appreciate the continuance hearing you guys allowed us to have. So I won't take a lot of your time up, but I wanted to just kind of go down memory lane of when this started. It won't take me long. So we stumbled upon this property back in March 2001, and we gave ourselves about 4 months of due diligence before we actually closed on the property, obviously to make sure it was a property that was going to be able to be rezoned. So when we met with Jen Klitsch, March of last year, she steered us in the direction of going through this rezone as opposed to a PUD or any other avenue. Maybe she knew something that Greg just shared with us as far as to go through the PUD process, you need to have public water, public sewer. So she said it didn't increase our chances to go the PUD way or this way, so we went this way, okay? Went through all our community Zoom meetings, went through our bank financing, received as-built commercial appraisal from our lender for $1.8 million, purchased the property for $645,000, whereas this is all public information, whereas lots 2, 3, and 4, they're right around that $180,000 mark. We closed on the property July 28th of last year, so four months after we started the due diligence with Jen and the county. We continued working with her through January and into February, and that's where Greg took over. Middle of February, we met with Greg at the office here, and he informed us that the commissioners recently denied Lot 2 for a similar rezone. Not similar, though. They wanted to do an RV park, and I understand the community and everybody was against that. So, as we've talked about before, it was bad timing on our part. We kind of got shuffled into the Lot 2 mess. So again, when we met with Greg, he mentioned that the only way this could potentially get approved is if we got lots 2, 3, and 4 to all potentially agree to go commercial. Meanwhile, I'm pretty sure lots 3 and 4 already had residential structural plans and building plans into the county. So that wasn't a possibility for them all to agree to go commercial. Not a problem. So Greg needed some additional information from us all through March, April of this year, just to wrap up that site plan, landscape plan, this, that, and the other. As he mentioned, June we met with the planning commissioners, 5 out of 6, I believe. All liked the concept, said, yeah, why not? Met with you guys 2 months ago on June 22nd. You guys didn't mind our concept. I'm going to say you liked it, but everybody was at a standstill as far as, okay, how do we get this? So backing up, in March of last year, if Jen would have told us this has already been rezoned once, this can't be part of the EDZ, it's joined to another residential property, we would have pulled the plug. We would have never bought this property for $645, which is why we gave ourselves 4 months of due diligence. That's all she had to say. You have a 10% chance, or no chance, or it's 50-50. Then we would have made our decision. That was never brought up. She was in support of it. Obviously, she doesn't make the final decision, but she was great. She pushed us through the process. Obviously, not bad advice. It just wasn't able to go that route. So after we met with you guys, we met with Greg the following week, 1 to 2 weeks after, because he was great. He said, hey, let's come up with some solution, some idea. Met with him, said, okay, well, maybe we can get with the county attorney. They can make a special amendment or do something to make this go through. At that point, he was still pushing towards, maybe the PUD process wouldn't give me a guarantee, which I respect, I understand that. and still said, see if you could get lots 2, 3, and 4 support. So, lot 2, we have an owner support letter. They're fine with it. Lot 3, we have an email from the seller. So, lot 3 owner emailed the seller stating that she likes our concepts. She's okay with it if we're held to the concept standards. Lot 4 spoke with that gentleman for 30 minutes. Nice guy, liked our concepts. And then he emailed me last week and said, I don't necessarily want you to get a commercial rezone, but I would be okay with you guys getting residential with special use. Obviously, that makes no sense. We purchased a property for $645,000 and it's residential. That doesn't do us any good. And as Greg just mentioned too, special use might not apply to what we're looking to do. The biggest issue that we've heard in the last year and a half is everyone's concerned with the appearance of this. They don't want it to look like a DB Speed. The funny thing is, if it's not rezoned to commercial and it's just going to keep the residential status, we could build a giant pink, purple, yellow house, not landscape it, do whatever we wanted with it. As soon as you're coming over the hill, that's what you'd see. It's not our intent. Commercial, we're held to a standard. We're going to build something beautiful that has already appraised and is going to help all the surrounding businesses and residential homes, because it is a custom show home. So in our opinion, I feel like that rezone of commercial is going to hold us to a higher standard, and we're going to produce a better project. And again, as you guys talked about, it is a busy road. So to keep it residential and us just to throw a custom home on there and sell it and have kids playing ball in the front yard right on 166 that's ever expanding, getting busier all the time, we feel like logic and common sense kind of sways us towards that is a good commercial lot. That's all I have.
Oh, thank you for that. And, yeah, truly, it's a unique situation for the county. So, and I totally understand the frustration on your side. I guess part of our decision making is, the fact that we're making decisions is because a lot of this is in the gray area. So if that's where we're at, that's where we're at. That's fine.
And I failed to mention the 60,000 plus that we're out of pocket on permitting, architectural renderings, engineering, bank interest. So I know that's not your pocketbook, but we were kind of led in that direction. So therefore, we had to do what was needed for that entire build package, which costs a lot of money, as you know.
Yeah, understood. Any questions for?
Yeah. In my mind, this is a good commercial lot, but it's in a residential subdivision. So would you accept as a condition of approval that you would document acceptance of all the lot owners within Wind Spirit Ranch, that they found that lot 1 becoming a commercial lot?
So from my understanding, and Mitch Trevy's here as well, he might be able to weigh in on this. My understanding is when lots 2, 3, and 4 purchased and closed on those properties, the CCRs and HOAs expressly mentioned that lot 1 would be commercial, and they
didn't change the plat.
Remember, I think we talked about replatting, and Greg said that wasn't.
No, it's a residential subdivision regardless of what the late filed.
Yeah, back in 2007 it was.
Yeah. If you could agree to a condition of approval that you'd get an acceptance by the other 3 people of Wind Spirit Ranch, I would be in favor of this. If you do not accept that condition of approval, I can't vote yes.
What if we weren't able to obtain, lot 4, for example? He likes our concept, but he's like, no, I want it to stay residentially zoned and get them a special use. So what if I'm not able to procure those agreements?
But then he bought the lot under false assurances that it was a residential subdivision. So what I'm trying to do is get this, I want this thing to become a commercial lot.
I appreciate that.
But we have to recognize that this is a residential subdivision. Now, the person that subdivided these lots, he made a mistake in the first place. And to be quite frank with you, it puzzles the heck out of me, because when I read all the documents, it looked like he was thinking about making it commercial at the time, but that's not what he filed. That's not what he went through the application process. But if you'll accept this one more condition of approval, and that's up to you guys to go and negotiate with him on what basis, I'm not going to say, because that's your business, not mine. But my guess is that if you go with the right attitude towards a negotiation, usually negotiations can be, you can find a manner and a reasonable acquiescence.
I just want to make sure I'm hearing you correctly. So are you stating there's a possibility for a rezone to commercial if I get lots 2, 3, and 4 to sign a owner support letter, or what would that look like?
I'm going to defer to an attorney, but in my mind, it would be just a letter to the CDS that says, we agree that this is an acceptable revision to the plat. And I'm not sure I'm using the right terminology there.
We'll kind of circle back to that in a moment. Do you have any comments? Okay. Yeah, I mean, I know I was kind of the stick in the mud at the last hearing, because it just did not appear to me in my reading of our regulations that this was something supportable. I was kind of hoping to get when I asked the question of the CDS director if this application could be approved if it was supported by our regulations. You know, it's a lengthy answer, and I'm not trying to denigrate the answer. I appreciate the background, but kind of the final answer that it's kind of a gray area. I mean, that is what boards exist for. If it was simple check yes or no, if it's all yes, it's a good. That doesn't require a decision. It just requires administrative work. So, I mean, I'm comfortable it's a decision we can make today, and it's something, if the answer is yes, it's not something that is outside of the regulations we have. So, Bart, looked like you wanted to weigh in on the earlier discussion.
Yeah, I think if this is what the board is contemplating, I'm not sure I'd be comfortable being able to come up with this specific terminology right here, right now. I think I would need some time to look at that, but I would also have some concerns.
Yeah.
There may be, I'd want to look at the deeds. I'd want to look at the plat. I'd want to look at any restrictions, any covenants, anything like that. And you can't just, this board's decision does not negate those if those are in place. So there's a lot of unknowns that this potential condition of approval does not resolve potentially other outstanding issues, is what I'm saying.
And that, I guess, honestly was kind of my concern as we also open the gates. I mean, this is the third hearing we've held today. One certainly had a lot of neighboring people that were not in favor of it, and yet our answer was yes, and it was supported by regulations. So everything we did say at the last hearing in terms of, you know, we want to see more commercial activity. We want to see businesses thrive in the county. I think it is appropriate. And like I said, this has been a unique one in terms of, you know, there's some covenants that are a little bit hinky, to say the least, in terms of when they were filed versus when properties were sold, and were all the owners actually party to them when they were filed. But at end state, you know, I do want to be careful going forward, and it really doesn't seem to be the case. I mean, if you accept the covenants that have been filed, then commercial activity on that lot is acceptable under the covenants. I think we'd be in a very different position than we were with Lot 2, where the covenants, if accepted, though they're not, the county isn't bound by them, you would potentially be granting the ability to have a commercial enterprise when the covenant said all you can have is a residence, and you've potentially rezoned to something that covenants would never allow you to do, and you've now got a piece of property that is unusable. There's two different authorities saying you can't do that, nor can you do anything else, and that certainly was not right. I mean, at this point, I'm in favor of going forward based on the fact that our regulations as they stand would allow it, or at least it's a gray area where we decide. I do think our regulations need to be clarified in how do you deal with changes to an existing subdivision, especially if it's changes in use. But I don't think we should leave an owner hanging forever on what is that answer going to be. So, I mean, I'm supportive of it. It would be wonderful if everybody always agreed that somebody's use of their property was appropriate. But as the owner, I think you've got more of a say in what's appropriate on your property, as long as it's not, causing any objective harm to others. So that's kind of where I'm at.
I don't know. I mean, I look at what we've done in the past and stuff, and looking at those covenants, they were recorded after Lot 2 was sold and things like that. I know what the intent is, and I think it's an appropriate site there to do that. So, I mean, I don't think the covenants necessarily, or the regulations necessarily prohibit what we're doing. I know we've looked in the past that we don't want a bunch of commercial in residential subdivisions. This is along 166 where there is commercial. So, I mean, that's my feeling. I think it's appropriate for the area. It's just a question of, how do we look at commercial in a residential subdivision. In this case, to me, it's not in the middle of the subdivision. So, I mean, that's my I just go back and forth on this.
Yeah, and it is unique because it's not heavy industrial. I mean, it is a custom show home with a custom barn, so it's going to fit in. Unless we didn't have a marquee sign up there, you wouldn't even know that it was commercial. So it is unique, I get that. But it's also why I think the seller agreed to sell it to us, because he didn't want someone with a heavy industrial commercial use buying that property. And I mean, we've been Liscott Custom Homes for 25 years in the same location in Castle Rock, and done a good job for a long time, and we keep a clean shop, clean office, and build quality homes. So it is.
Would you accept my condition of approval?
Yeah, I'm just, my concern, I appreciate that. My concern is if I don't get lots 2, 3, and 4, then I guess we're just back to square one.
Well, I'm assuming that you'd negotiate with whoever it is.
Yeah.
If you'll accept this, or something similar to what I said here as a condition of approval, I have no objection to it. But if you don't, then I don't know what to do.
Yeah, no, I appreciate that. I think over time, I don't know how long it may take, and I know we have 2 out of the 3 that probably get on board, maybe all 3 after a matter of time, but...
Just find out what kind of ice cream they like.
I know. Just leave money in their bell box or something.
I think we're, honestly, I totally trust the intent, and I think what you're trying to accomplish, but I think we're we're asking something that sets a really bad precedent that may not help us in the future either.
Having had some more time to consider it, I don't think that's a good condition to include. I understand the intent behind it, but having conditional zoning concerns me for a number of reasons. So I think you really have to make a decision on the merits as they stand today, without putting that particular set of conditions in there, which incredibly complicates thing and potentially is illegal. So.
Hey, Bart, can we ask you about an amendment we found that just scouring through hours of, county documents? Can we ask you about an amendment and see if it would apply?
I'm not going to be able to give you a particular legal opinion as a private individual.
Could you, I would, if you could, what was the amendment you found, just so we know? Yeah.
So, I understand the rezoning, the regulations, and not wanting to open a can of worms from any direction, because it does open, anything opens up anything. You're probably in the gray area. It is what it is. But from a rezoning and legal statute, and Mitch Trevy's here, I'd like him to have a few words after me anyway, but the history of this project from clear back to 2007 to current is very unique. I think everybody here in the room can agree with that. I don't think there's a doubt that this was supposed to be a commercial lot. I believe that was its intent. I believe that's how it started in 2007. I believe that's how it was led all the way through it. I guess my question is why can't this specific project, say we agree to get the four other neighbors, or the three other people to agree to that? I think that's a reasonable request. On top of that, how come the county attorney or board of commissioners can't look at this project as a one-off? It doesn't have to be county-wide. I don't think this particular project exists anywhere else in the county, and if it does, oh man, there's a lot of bad stuff going on. But this is such a one-off opportunity. The project sits along 161. It's surrounded by the EDZ. It was originally intended from 2007. It's got covenants in there pulling lot 1 out of it. It's got commercial water to it. So I guess my question is there a way that this could be under a special use amendment to the zoning regulations and call out all these special requirements that this project falls under, so that way it can't be a blanket term for other people to use?
Okay.
And that would be the question.
I understand what you're asking. I would say that every application is considered individually against the requirements of the county. So everyone is unique. Obviously, over time, we kind of, develop a rhythm of thinking. Maybe they're not really precedents and shouldn't be applied that way, because each application has to stand alone and be compared against what's required. Again, if we're in a gray area where it clearly isn't, no, it can't be done. Our tradition, our mindset, and most regulatory things within the county is if it's not in there and it doesn't say you can't, then we should consider yes. It's not, if it doesn't say you can, you can't, because you can't write regulation to cover every possible eventuality. I am concerned, again, and as I said, going forward, Singing Hills is a busy road, as we've been mentioned. Widening in the future is very likely, and there's a lot of residential properties that will be greatly consumed by roadway and shoulders and whatnot that will, we're going to have this problem. We're going to face this with existing subdivisions that are built out with residences in the future. So it's a big warning flag to us, but I think what you're asking to do, again, regulations don't say you can't, and it makes sense based on how that area has developed over time and what you're trying to do. I am supportive. We've not heard anybody come out and say no, you shouldn't do this. I mean, to your point, I mean, it's certainly, there's been quite a bit of communication. Your neighbors are aware of what the neighboring properties, the neighboring lot owners are certainly aware of what your intent is. And I'm glad there's communication amongst yourselves and Mr. Trevi and previous owner that's been passed on, but in a public hearing process, they haven't stepped up and said, absolutely not, we don't want this either. So, they've had that opportunity, an ample opportunity before the Planning Commission and here. So, like I said, my hesitancy during the first session really was I wasn't seeing the mechanism for this to happen, and maybe the fact that there's no mechanism that says it can't happen is enough comfort for me to be able to do the right thing for the right reasons that make sense. So,
Any other questions for applicants?
I do not.
Did we close public comment the last time
I do
when we
not
had the hearing?
recall.
I don't believe so.
Okay.
It was,
In that.
there's a couple neighbors that was here in
Oh,
support
okay.
of it. And
Okay.
Gary, I think, was
Yes, if I remember last time, it was just yourselves that. Or did you
the
have?
neighbors showed up and.
Oh, okay. Okay.
They
Yeah.
come back with it, someone come make it.
Alrighty. Well, in that case, if it's unclear whether we closed, we'll open and ask for public comment at this time. So, ma'am, if you had something to say, thank you. Yeah, please. Yeah, we just ask for your name and address, and you have about 3 minutes.
Hi, my name's Rebecca Zambrano, and I own Lot 3. I currently live on 12926 Ironstone Way in Parker. I'm the owner of Lot 3. I have a building permit for a home. We have a home up in frame. I did hear from Gary, who was the seller for our lots. Mr. Gary did mention since the get-go, when we initially put a contract on the lot, that Lot 1 was going to be rezoned commercial. That was my understanding. I knew the covenants applied for all of the subdivisions. I guess the only reason why I'm up here today is because I really like what Gary sent me as far as their plans. I really do like it. I think it's clean cut. It's not like DB Speed. It's not something that Lot 2 owner was proposing. I also feel as a Elbert County resident that it's beneficial for our county as far as the business. My only, or one of my biggest concern is setting precedents to allow Lot 1 to become commercial. What will that do in the future for Lot 2, which was previously denied? I am next to Lot 2, and I absolutely do not want Lot 2 to become commercial. That's my main concern. And if I become approval of something that I really do like, how is that going to affect me in the future? I don't want to be sitting here every so often with hearings. I didn't sign up for that when I purchased the lot. Another reason is, and I'm glad to hear that you've been 25 years, I think I heard, in Castle Rock. I'm concerned if it's set to commercial, that if they decide they want to move out of state, or they just want to close the business or move to Broomfield, what is the next owner for commercial lot going to build on that? Like I said, my biggest concern, and the reason I'm standing here, it's Lot 2. I don't want to set any precedents for the young lady that applied for the RV lot, that's going to give her any lead to come back and reopen and reapply, especially now that for some weird reason she is now working for Elbert County. That's all I have to say. Thank you.
Thank you, ma'am. Ma'am?
So I'm Vivian Peterson at 655 Madrid Court. I actually own both of the lots that back up to it, which for some reason that's not included as the residential, even though it is, that is our backyard. And I agree with Rebecca. What they're proposing looks good. I do not want this to be a precedent for Lot 2 to be able to go industrial. And I am concerned about what it would bring in if they were to sell the lot. So I am I'm just reiterating what Rebecca said, what our neighborhood concerns are.
No, I appreciate that, and thank you. And as I did say earlier, every one of these every application is judged against regulations and the specific circumstances of the application. So I would not look at any decision today as a precedent for any other decision to be made. I mean, it'll be a condition that exists in the future if approved, but not a precedent. Mr. Trevi.
Thank you, Mr. Chairman, Commissioners. Mitch Trevi from Trevi Commercial. I'm at 10510 Transfelt Road in Parker, Colorado. As it's common knowledge, we were the brokerage firm that represented the 4 lots for sale. And early on, the developer, Mr. Gary Levinson, explained to us that when he went through that subdivision process, it was clearly stated with the county that this was intended to be commercial. Granted, when he filed his plat, he did not record the covenants, which were actually drafted back in 2007. He just failed to record them. So understood, that left us open for the situation that we're in right now. So, and it's unfortunate because as Mr. Levinson presented the property to us, I too checked off with the county before I went to market, confirming that this lot was eligible for commercial zoning. And so it was marketed that way and sold that way. And so this is not me trying to cover myself as much as give you some background on that as well. I do like some of the comments that I've heard from the board with regard to the highest and best use and it being a commercial lot and support for commercial and common sense. I think it does make common sense. I mean, if this property was sitting just zoned ag and it was coming in not a part of a residential subdivision and somebody was petitioning for zoning for residential, I think there would be concern there because if anybody wanted to zone that for residential and build a home that close to Singing Hills, the commission would probably be looking at saying, you know what, that's a dangerous place to be building homes, particularly with what the future holds for Singing Hills. Understood that Singing Hills is going to be expanded, additional right-of-way taken. The highest and best use for that property is indeed commercial from a market standpoint and from a public safety standpoint, definitely from an economic development standpoint. So I do like the fact that you in particular, Mr. Chairman, have indicated that there is some discretion that's available to you as commissioners when there's not a clear-cut regulation that says that you can't, then it is left to your discretion. I do also like your comment where you indicated that any discretionary approval is not necessarily going to set a precedent because you do treat every application individually. That's very honorable. So I just wanted to put in my 2 cents worth, and also as a member of the county's new Economic Development Council, I would certainly love to see commercial come in on this property just for the health and the wealth of the community. So thank you very much for your time.
Thank you, Mr. Trevi. Do we have any other comment? Okay, seeing none, I'll close public comment. Yeah. So what's the desire up here?
I'll make a motion that we approve Liscott Custom Homes rezone case RZ-21-0082 with conditions of approval as presented.
I'm going to abstain from the vote.
Okay, I will, in that case, I will second. Any final comment before vote? Or?
No.
Okay. Yeah, and like I said, I recognize the motion is for approval with the conditions that were presented. Also recognize that a rezone to commercial does open up all uses by right to commercial in the future. So I am glad you've chosen Elbert County to move your business to. I hope you stay for a long time to come. There will be changes along Singing Hills over the years coming forward. I'm not predicting anything, nor do I have anything in front of me applications-wise on that. I think it's just the natural progression out there. So if at some point you do leave and it continues to be a commercial application. There's still site planning, other things that need to be done, and I do believe that's something the county needs to look at for whether it's redevelopment or whatever term we use. We are going to have commercial businesses spring up where there had been residential in the past, or we may have, we have to look at buffering, we have to look at appropriate ways to address changes on the edges of current residential. I mean, we did so with the EDC in setting specific buffering for those areas where we were still ag, but bumping up against residential. But okay, and prior to the vote, Commissioner Thayer is asked to kind of explain his
The reason I'm
extension.
abstaining is that I want to vote yes, but I can't without the acquiescence, the acknowledgement of the other 3 lot holders there. And the reason for that in my mind is fairness. If they didn't know when they purchased those lots that their zoning was applicable in total for that subdivision, I don't think that's fair. And I don't want to vote no because I think this is the right place for commercial stuff, but fairness to the other people in the community, to me, is paramount.
Thank you. That being said, we've got a motion and a second on the table to approve with the conditions that were presented by staff. All in favor, please say aye.
Aye.
Aye. Motion carries. The application is approved with the conditions. I'd accept a motion to close public hearing at this time.
I'll make a motion, we close public hearing on Liscott Custom Homes rezone RZ-21-0082.
Second.
Okay, a motion and a second to close public hearing on this item. All in favor, please say aye.
Aye.
Aye. Motion carries. We're out of public hearing.
I'll make a motion, we adjourn.
Second.
Okay, a motion and a second to adjourn. All in favor, please say aye.
Aye.
Aye. Motion carries. We're adjourned for the day.